Hey guys, I'm Ted, and welcome back to our lecture series. We're at our third lecture on Laissez Faire. We're wrapping everything up. But before we do that, I'd like to get touch bases on what we discussed in our last lecture. Talk a little bit about what we talked in our last lecture. In our last lecture, we looked at the principle of the liberty of contract doctrine that were formulated by Thomas Cooley, lawyer and judge from Michigan. We also looked at two Supreme Court cases, Munn and Scott versus Illinois, and of course we looked at the Mugler case, Mugler versus Kansas. Both cases saw appeals made to the Supreme Court, sort of arguing for the liberty of contract doctrine, trying to get the court to side with them based on the liberty of contract doctrine. It didn't work out for Munn or Mugler. The court rejected both of those cases and upheld the state laws. In Mugler's case, it upheld state laws banning the sale of alcohol. In Munn's case, it upheld the laws banning their overcharging of farmers for storing grain in the city of Chicago. Now, with that being said, I'd like to jump right into to the lecture topic of today, and we begin with looking at really just looking at the dockets of the Supreme Court during this time. And railroad suits dominated the dockets of the courts across the country at the time. Railroads were very powerful. They wielded enormous economic and political clout. They could put economic pressure on just about anybody at any location, any locality. In 1890, the Supreme Court heard a case regarding a Minnesota state law over the establishment of a state commission to set reasonable railroad shipping rates. Now, in the years between the cases that we discussed, Chief Justice that we discussed in our last lecture, Chief Justice Morrison Wade had died, and President Grover Cleveland, a noted conservative Democrat, nominated Stephen Fuller to replace Wade. Now, Stephen Fuller was a former corporate attorney and a staunch conservative. Fuller's record goes all the way back to the Lincoln administration. Fuller denounced emancipation. He had denounced the Emancipation Proclamations. He had denounced Abraham Lincoln and all the other progressive initiatives of the mid-19th century, namely the civil rights initiatives of the 19th century. He was a very loyal lieutenant to the corporate employers. Fuller had served as a corporate attorney. And he was very loyal to those men. Even after he had left their service, he was still very loyal to them. And he began to set a judicial tone for the protection of big business once he became Chief Justice. He wasn't the only one, though. President Benjamin Harrison, in Harrison's lone term, he actually got to appoint a number of justices. Harrison got to set a number of justices in his lone term. He placed four justices on the court, all of whom were former corporate lawyers. So that gave the court a majority. Out of 9 justices, 5 are former corporate attorney. 5 are going to have very favorable a very favorable disposition to corporations, to big business. Harrison's first appointment was David Brewer of Kansas. He was one of the most conservative justices in the court's history. Henry Brown of Michigan, George Shears of Pennsylvania, and of course Howell Jackson of Tennessee. And these men were not distinguished in any way. Much like the presidents of the era, the Supreme Court justices of the era, with the exception of John Marshall Harlan, are not really distinguished. No one really knows them. No one really knows the chief justices of this era. They're just sort of like fillers, fillers on this conveyor belt. Brown gained notoriety on his own. He's distinguished. He gained some notoriety on its own because Brown wrote the majority opinion for the court's ruling in the Plessy v. Ferguson case. And his opinion that ruling is generally regarded as one of the worst, if not the worst, ruling in the United States Supreme Court's history. But this court would go on to strike down the Minnesota law in the case of Chicago, Milwaukee, and St. Paul Railway Company in a 6-3 decision. Sam Blatchford wrote for the majority decision, in which he stated that the law did not satisfy procedural due process at all. Associate Justice Joseph Bradley has supported the grain elevators in Chicago during the Munn case, but he now lodged a strong complaint with the court's decision, practically, and this is because that decision practically overturned the Munn decision. Now, this new court composition was composed of a majority of jurists who advocated for the liberty of contract and substantive due process. They were all advocates of those things, having been former corporate attorneys. In 1895, this new ascendant majority flexed their judicial muscle and their judicial authority in a trio of three, of course a trio with three, but in a trio of landmark decisions. This first case and this first decision largely limited the Sherman Antitrust Act, which was passed in 1890. Now, this decision, which Congress had passed in 1890 to curb the power of giant monopolies, was largely defanged, if you want to use it that way. The Sherman Antitrust Law made it a crime for a combination or a conspiracy to impede trade and interstate commerce. The federal government filed suit to break up the American Sugar Refinery Company and its subsidiaries, which had a near complete and total control of the sugar industry back in 1895. In the case of the United States versus E.C. Nye Sugar Company, the court ruled in an 8-1 decision to limit the reach of the United States government. Chief Justice Fuller wrote for the majority opinion, stated that the Commerce Clause of the United States Constitution did not give Congress the right to regulate the manufacture of products that were later shipped in interstate commercial transactions. It remains a very controversial decision, but it stood at the time. There was a majority of justices who supported it. It stood at the time. Now, the second case of 1895 involved the first national income tax, which imposed a 2% levy on personal income and corporate profits, with exemptions for those with incomes under $4,000. Now, this law freed most workers from paying taxes under this law and placed the burden on the wealthy. Now, one wealthy man, a Charles Pollock, filed suit on behalf of his fellow investors in the Farmers Loan and Trust Company to contest the law. Pollock's argument that the law violated Article 2 of the Constitution and the provision that no direct tax be levied on the people that was not in proportion to the census. Now, Chief Justice Fuller again wrote for a narrow majority of 5 that struck down the tax law. Fuller's ruling was controversial, like the previous ruling, and it remains so today. Fuller's ruling is controversial because it distorted history and previous court rulings and legal precedents and reinterpreted cases that went all the way back, as far back as actually the 1790s, all the way back to I think it was like the end of Washington's second term back in 1796. rectifying that, and he did this to rectify what he called a century of error on taxation. So he went back to the founding generations legal opinions and laws on taxes to rectify what the founders had put in place for taxation, which is one of the reasons why it remained controversial. Now, Justice Brown, who dissent from the majority opinion, stated that the decision was nothing less than the surrender of the taxation power to the money class. Now, the Pollock decision was resented by labor and progressive groups who were finally able to challenge the decision in 1912. Their opposition to this decision and the political strength they were able to wield led to the 16th Amendment. This amendment gave Congress the power to lay and collect taxes without regard to any census or enumeration from all sources of income. Now, this event marked the third time that Congress and the states reacted to an unpopular decision by the Supreme Court by simply amending the Constitution. This was the third time that it happened. And of course, the third case of 1895. The third case of 1895 also provoked widespread outrage and actually led to calls for judicial impeachment. In 1894, as we had already discussed, the railroad workers had joined a national strike under Eugene Debs against the Pullman Company for their practices. The strike brought railroad traffic to a sudden and complete halt. Federal lawyers were able to prod a pliant judge to issue a sweeping injunction against the railroad strikers. The railroad strikers and their actions. Now, the injunction banned strikers from persuading non-strikers to join them or from using force or violence. Now, Eugene Debs, he had vowed to defy the injunction and called on union members to refrain from violence. On July of 1894, tempers flared and strikers came to blow with federal troops, and an altercation erupted. Now, after this altercation, 13 people were dead and several hundred were jailed. Debs was arrested by federal marshals and sentenced to 2 years in federal prison. The Pullman strike fell apart after his arrest and conviction. Now, Debs appealed his conviction, but the court unanimously upheld his conviction. David Brewer wrote the court's opinion, which outright stated that the use of military force to suppress workers was acceptable and just to restore public order. Now, opinions in the Debs case were split along political lines, with some applauding the court ruling as saving the republic from anarchy, and their opponents taking the stance that the government by injunction was a highly dangerous form of oppression. Government by injunction, a highly dangerous form of oppression. I repeated the phrase. And many people still look toward the Debs case. And it remains controversial even today. Unanimous decision to keep Eugene Debs in jail. Very controversial. Tempers flare. Passions are inflamed because of that decision. Now, after the Republic entered the 20th century, the Supreme Court was tested by two cases that tested the contract of liberty doctrine. And these cases were largely the same, but were settled for very different reasons. We'll shortly see. The first of these cases was the Lochner case, Lochner versus New York. And this was pressed by labor unions like the American Federation of Labor, who favored bread and butter approaches, as we discussed earlier. They didn't want to change the world. They simply wanted better wages, better working conditions, very limited aims under Samuel Gompers. And of course the industrial workers of the world, the Wobblies, who favored that class warfare appeal. Now, in 1897, the New York State Legislature passed a statute that limited the working hours of bakers to 10 hours per day and 60 hours per week. Henry Weissman of the Journeyman Bakers Union was the driving force behind this piece of legislation. He presented lawmakers with documentation detailing the harmful health effects that bakers were subjected to in the unventilated work areas, and of course for was standing on their feet all day long. Now, Joseph Lochner, who owned a small bakery in Utica in upstate New York, found himself, under investigation when some of his employees complained to a New York State inspector that Lochner was violating the law. Lochner was violating the law, and he was duly convicted and fined $50 for making his employees work more than 60 hours a week. Now, Lochner appealed with the he appealed to the New York State Court of Appeals. Lochner appealed to that. He appealed to them. He lost his appeal. After that, he appealed to the United States Supreme Court, citing the liberty of contract doctrine, and called on the court to closely scrutinize the attempts of the state of New York to regulate business. The justices narrowly decided the case, and they ruled in Lochner's favor along that 5-4 majority decision. Remember, they have this five former corporate justice majority on the court, and they're all ruling whenever a suit comes up that involves big business. They're all ruling for big business. Now, Lochner, in the Lochner case, Justice Peckham opened his opinion by stating that the decision conflicted with the right of contract and business. He further stated that New York State and the New York State law was an overreach of the state's policing powers and served no health benefit at all. John Marshall Harlan, our great dissenter, still sitting on the court, wrote the dissent, and he wrote a dissent that rested on judicial restraint while championing the law, the New York State law, had fulfilling its original aim and purpose. Justice Oliver Wendell Holmes also wrote a dissent, and his dissent was brief. It was only 2 pages in length, but it was packed with powerful rhetoric and powerful punches aimed at the ascendant corporate lawyer majority on the Supreme Court. Holmes squarely rebuked the doctrine of power, the doctrine of liberty contract. Holmes cautioned that the Constitution does not favor or protect any particular economic theory, be it paternalism or laissez-faire. The ruling held sway for the next 30 years and generally served to define the court's attitude towards labor laws and laws that encroached on the liberty of contract, with one exception. That exception was the Oregon State Legislature law passed in the early 1900s and early 20th century that limited the hours that laundresses could work to 10 hours per day. Now, the Oregon law was challenged by an Oregon man named Kurt Muller, who owned the Lace House Laundry of Portland. Muller, like Lochner, had been convicted and fined for violating the state law. He was fined $10 for having an employee work longer than the 10 hours. Now, Muller took his case to the Supreme Court. He filed an appeal with the Supreme Court. And Oregon, having walked and observed what happened with New York, decided to not take any chances, and they hired Louis Brandeis. Now, Louis Brandeis was a very bright and young lawyer, an energetic lawyer. Brandeis was known as the people's lawyer, and he successfully presented a report on the damaging effect of long hours of laundry work to the court. The court unanimously decided to uphold David Muller's conviction. David Brewer wrote the court's decision, and he cited the Lochner case for the right to set work hours, but he also looked to what he called the special physical organization of women to justify his exception to the Lochner case. So Mueller lost his case. Mueller lost his Supreme Court appeal, not because the justices thought that Oregon had everything right for their law. Mueller lost his case because the justices were exhibiting sexism. They believed that it was okay for a man to work this hour, but when it came to women, women just aren't as sturdy as men. When women aren't as capable to endure work as men, so we had to take in special consideration for women because of their special physical characteristics. But it was a victory. It was a victory. Mueller's conviction was upheld, and the Oregon law stood on the book. But again, this was an exception. All the other cases that came before the court were decided in favor of the business owners, of the employer, not the employee. And we'll end there. That's the end of our lectures on Laissez Faire. Hit like, subscribe, and comment. Let me know what you thought about the case. A lot of classes, you know, they're kind of ambivalent. They don't really know how to take those last two cases, Lochner and Mueller. They don't know how to interpret those cases. A while back, the descendants of Lochner actually gave an interview where they were proud about the fact that he won the case, but couldn't really answer about the ill and harmful effects of inhaling all that flour dust and force people to stand on their feet for more than 10 hours. But that's neither here nor there, really, for our lecture purposes. But like, subscribe, and comment, and let me know what you thought about the cases. Let me know what you think about the way that the Supreme Court handled these laissez-faire cases. As always, I'm Ted, and I'll see you guys next time for another lecture.